My name is Shauna Brown, and I'm an attorney here in the Elder Law Department at Manel Baum Barrett. And this week, I read a story in the New York Times about the death of Juan Hamilton, who was a caretaker, confidant, and protege of the renowned painter Georgia O'Keeffe, who died in 1986. So when they met, Juan was 27 and Georgia was 85 years old. She was childless, widowed. She didn't live near any of her relatives, and most of the people she interacted with were strangers who came to kind of bask in her artistic aura. Juan was one of those people, and they first met over some odd jobs, and that turned into him traveling with her, handling her correspondence, becoming her editor and curator. It got to the point where if you wanted to get to Georgia to do a project or an exhibition, you had to go through Juan first. They were so close that in the 1970s, a magazine article actually featured Juan and Georgia in a feature about May-December relationships. And they actually reportedly did not have a romantic relationship, but they were really close. Juan became Georgia's power of attorney. He had control of her affairs, and he eventually married and had his own family, and they lived with Georgia. When she died in 1986 at the age of 98, you know where I'm going with this, she had a will that had been done only a couple of years prior in her late 90s, and she left about $90 million worth of artwork to Juan. So after she died, one of Georgia's nieces brought Juan to court alleging that he had unduly influenced Georgia to leave those assets to him, so they were not happy with him. In the end, the case settled, and the estate passed in accordance with a prior will of Georgia's that left millions to her family. Juan still got most of her property, and a foundation was established to manage most of her estate. And it was widely reported that it was Juan and not Georgia's family who had taken care of her in her later years, gave her a lot of joy and purpose, and that Juan was the son she never had, and that he had promised to protect her artistic vision, which was why she rewarded him. So this case involves a famous artist, but we see these facts all the time with quote unquote normal families. And often there is a situation where someone dies and leaves the bulk of their estate to maybe a singular caretaker or friend or a relative who is the primary person who is with them at the end of their life. Maybe that's a caretaker, maybe it's someone local, maybe it's someone helping them with a business. While other relatives or friends, maybe they're burdened by other life issues and they're just not as close, or they stay away or they live further away. You know, what'll happen is the person who's receiving the estate will have that challenged by other relatives who say, you know, you were with them all the time, you were influencing them. And, sometimes that's a successful case, especially if the person who receives most of the estate was taking action to isolate the person from others, or there's evidence that they were really, really pressuring them, unduly influencing them to leave their estate to them. On the other hand, sometimes there is a primary caretaker or a primary relative that is the person who's around at the end of their life, and they give their estate to them out of gratitude for that. And sometimes, that is what it is. There's no undue influence. Here at Manel Baum Barrett, we guide clients in these positions all the time, and we represent both these beneficiaries who get these large estates, and also the family who might be challenging such a beneficiary designation in a will. And knowing both sides of the case helps us to anticipate how a case is going to progress and what kinds of arguments will be made, so that we can zealously advocate for our clients and guide you to an amenable resolution to your case.